Hey everyone, and welcome to my channel. We're all very used to borders. We're surrounded by them, in fact, whether they be provincial borders, state borders, international borders, and we all know that when you cross an international border, you need to have one of these, a passport or some sort of travel document. What we're not used to, though, is needing something like this in order to cross state borders within a country. But that's becoming the norm within Australia in the days of COVID-19. This has raised a lot of questions about these borders, whether they're legal, how long they'll last, and whether they're even constitutional. And I'm going to try and tackle some of these questions in this video. Back in March, Tasmania was the first state in Australia to close its borders, and since then, almost every single state and territory in Australia has imposed some sort of border restrictions in one way or another. Now, not all of these restrictions are the same. Different states have taken different approaches. For example, right now, Western Australia has a hard border closure, and no one from anywhere in Australia can enter Western Australia unless they're an exempt individual, which essentially means that they're entering for essential purposes. Queensland, by contrast, has a hotspot system that they use, meaning that they designate certain areas as hotspots and people can't come into Queensland from those hotspots. Just so happens that right now those hotspots include all of Victoria, all of New South Wales, and the Australian Capital Territory. So what is the legal framework behind these border closures? It's true that Parliament hasn't passed laws that say that these borders are closed, but what is the case is that in all of the states and territories, Parliament has passed laws in the form of health acts and emergency management acts that allow for members of the government, whether it be chief health officers or ministers of the Crown, to make determinations or to issue directions that people must follow. In the case of border closures, there are directions and determinations in place in the various states and territories that have border closures right now that state that the border is closed and that people can't cross that border without following the proper procedures. Because the statutes that have been passed by Parliament in the past allow these officers of the state to make these directions and determinations, those directions and determinations have the force of law. And the acts that allow those directions and determinations to be made state that when a person does not follow those directions and determinations, they're subject to a penalty of one kind or another, whether that be a fine or imprisonment or both. Now, because that's the case, those directions themselves have the force of law, and anyone who violates those directions is not just violating those directions, but also violating the law that has been passed by Parliament. So that's the legal basis for them. In terms of how long these measures are going to last, it's really quite hard to say. The reason for that is that this virus, the scenario that we're in right now, is totally unpredictable. There could be an outbreak in one part of the country that's unforeseeable right now that will result in a border closure that will prohibit those people from entering another state. The situation that's going on in states like Victoria right now could last for longer, and as a result, it's hard to tell how long these border closures will be necessary. Now, on the political side of things, there is a lot of pressure for borders to be open because of the impact that these closures are having on interstate trade and commerce. In fact, we're seeing the Prime Minister saying that he wants all state borders open by Christmas time. I think that that's probably a likely date, and if we do see border measures in place after Christmas time, they'll likely not be hard border closures and more be targeted hotspot approaches that are targeted at preventing COVID-19 from entering states from specific areas that have been designated as hotspots. Now, of course, the big question is whether or not these border closure measures or these border restriction measures are constitutional. And the constitutional issue that they run into is found in Section 92 of the Commonwealth of Australia Constitution, which provides that on the imposition of uniform duties of customs, trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Now, although this section seems quite simple and quite easy to understand, meaning that there must be a freedom of movement, there must be no barriers to trade or commerce, it's actually proved to be a lot more complicated in practice, and courts have struggled over this for a number of years. In fact, between Federation in 1901 and the hearing of the leading case of Cole and Whitfield in 1988, the High Court and the Privy Council combined heard approximately 140 cases concerning Section 92 of the Commonwealth Constitution, and that accounted for 1/3 of the cases that went before those bodies concerning the Constitution of Australia. Because this section has proved so difficult to interpret, there have been a number of interpretations over the years about what it means. If we look back to 1945, a case came before the High Court called Gratwick and Johnson, and that case actually arose under circumstances that are very similar to the circumstances under which the closed borders are emerging today. At the time, Australia was in the midst of a national crisis. World War II was in full swing, and the Commonwealth Parliament had enacted a National Security Act which allowed for orders to be made. One of the orders that was made at the time was an order that prohibited interstate travel without a permit by rail. Now, Miss Johnson, who was living in South Australia at the time, decided to go and visit her fiancé, who was living in Western Australia, and she traveled by rail, but she neglected to get a permit, so she was charged under that order. When the case made its way to the High Court, Justice Stark said that the freedom in Section 92 of the Constitution is a freedom to pass to and fro among the states without burden, hindrance, or restriction. He actually even went further than that to say that even if the measure is not targeted at stopping people from moving between states and is instead targeted at preserving national security or public safety, then it will still be unconstitutional because Section 92 provides an absolute freedom to move in between the states. Now, the High Court has moved away from this interpretation of it more recently, and in Cole and Whitfield, the High Court unanimously determined that Section 92 was subject to limitations and that there are measures that the Commonwealth and states can put in place that limit the otherwise seemingly absolute rights under Section 92. In Cole and Whitfield in 1988, the High Court unanimously held that the freedoms in Section 92 of the Constitution are not absolute freedoms, and that certain measures can be put in place that limit those freedoms, provided that they are not targeted specifically at limiting those freedoms, and provided that they're not discriminatory measures that provide for different treatments based on which state products are coming from, and provided that the measures put in place are not protectionist measures. Although the High Court did seem to make it clear that the restrictions put on trade and commerce could be more comprehensive than the restrictions put on intercourse between the states, they did specifically state that intercourse between the states can be restricted in certain ways, giving a couple of examples. One being that it is perfectly acceptable to stop someone from walking on a highway in between states in the interest of public safety. Now, the High Court elaborated further on what they commented on in Cole and Whitfield, and I should mention that they didn't really discuss the intercourse aspect of Section 92 in Cole and Whitfield because it was concerning the trade and commerce aspects of Section 92 more specifically. More recently, in a 1994 case called Cunliffe and the Commonwealth, Chief Justice Mason observed that limits can be put on intercourse between the states provided that they're reasonably necessary for the purpose of preserving an ordered society under a system of representative government and democracy, and the burden or restriction is not disproportionate to that end. Now, this seems to be the approach that's been taken going forward, and in the Palmer and Western Australia case, which is right now being litigated and is going to be heard by the High Court in the near future, the federal court, which was making certain findings of fact but not deciding the ultimate matter of whether or not the border closures are constitutional, observed in obiter that it's possible that the test that will be adopted to determine whether or not these measures, these border closure measures, are ones that infringe Section 92 of the Constitution will be the same test that's used to determine whether or not a measure infringes the right to freedom of political communication. And that test ultimately is a three-step test. The first question under this test is to determine whether or not the measures that have been put in place burden the freedom in terms of their terms, operation, or effect. In this case, we can accept that the measures that have been put in place, namely the border closure measures, do burden the freedom to move between the states. Now, the second question that this test requires to be asked is whether or not the purpose of the measures and the means adopted to achieve that purpose are legitimate in the sense that they're compatible with the maintenance of the constitutionally prescribed system of government. In this case, the measures are not targeted at limiting intercourse between the states. The measures are targeted at preventing the spread of COVID-19. And that is something that I think can be accepted as something that is acceptable within the constitutionally prescribed system of government. Now, the third step of the test that the High Court has put forward for freedom of political communication is a three-step test. It's a proportionality test, and it involves three further steps. So the first question that's asked under the proportionality test is whether or not the measure is suitable. With regards to suitability, the question is whether or not there's a rational connection between the measure that's been put in place and the objective of that measure. Is there a rational connection between these border closures and reducing the risk of COVID-19? And the federal court seems to indicate that there is a rational connection, that these measures do seem to be reducing the risk of COVID-19 spreading between the states. Which brings us to the second question under this third step of the test, which is whether or not the measures are necessary in the sense that there's no obvious or compelling alternative that's reasonably practicable and achieves the same purpose with a less restrictive effect. The federal court here seems to also indicate that other measures wouldn't be appropriate. For example, the common measures that we're seeing in states, social distancing, contact tracing, and testing don't have the same impact in terms of reducing the spread of COVID-19 as border closures do. Border closures seem to be extremely effective, and other measures just aren't nearly as effective. In fact, the federal court even found that in the case of Western Australia, which has a hard border closure, even requiring travelers who are traveling to Western Australia to undergo 2 weeks of hotel quarantine wouldn't be a reasonable alternative because it quite simply wouldn't be something that's practicable. The state currently has 6 quarantine hotels that it's using, and its maximum capacity in order to run the program properly is about 7. So if every single person who is traveling into Western Australia were required to undergo hotel quarantine, even if they were coming from within Australia, then that would overburden that system. Therefore, that's not really a practicable alternative, and the border closures are really the only practicable alternative. Now, the final question under this third step of the test is whether or not the measures are adequate in their balance. And this is basically a value judgment that determines whether or not the burdening effect that this measure is having on the Section 92 right is proportionate to the beneficial effect of reducing the spread of COVID-19. So are the restrictions on interstate travel and the effects that stem from that more burdensome than the positive effects of preventing the spread of COVID-19? In this case, I'm going to suggest that the measures are adequate in their balance. The federal court said quite clearly that if community spread were to start to propagate in states that currently don't have any community spread, the results could be catastrophic. As a result of that, the burden that this is having on interstate travel, and it's important to remember that there's a lot of interstate travel that's still allowed to happen. Truck drivers are still allowed to go in between states, other essential workers, there are a lot of exempt individuals that can still go in between states without having to undergo mandatory hotel quarantine. Because those people are still allowed to move throughout the country and get their goods to market, and the effect of this measure tends to target recreational travelers, social travelers, vacationers. Although, yes, it might be having an impact on trade and commerce, the impact of COVID-19 getting into these states and spreading in the community would be much worse than the burden that this is having on the economy or anything else. And in light of that, these measures are probably constitutional, and the border closures are here to stay for the next couple of months, or at least until COVID-19 comes under control in the parts of Australia where it continues to spread. If you enjoyed watching this video, found it helpful, found it interesting, feel free to subscribe to this channel, like this video, and if you have any comments about how to make this better, or if there's anything that you'd like to hear going forward in the future, drop that in the comments down below.